Good evening, ladies and gentlemen, and I welcome you once again to our premises here, Jakob Marengo Chambers. I unfortunately have the inauspicious task of speaking after the esteemed judge of the High Court. And you've heard me being introduced, and I must also echo that I was looking at my colleagues and wondering who was spoken about. In any event, this duty was thrust upon me as, unfortunately, the face of this chambers. My colleagues do not like to speak in front of other people apart from making their arguments in court. So the duty was thrust upon me to represent our chambers and say a word or two. After the comments of Judge Masuku, I simply have one or two points to make. I think we're running out of time and people need to network as well. I was thinking of this book when I was engaged to say something. And what immediately came to mind, and having read some parts of the book in the time that I was afforded, it dawned upon me that it might have had a very ambitious jurisprudential approach. I say that for one reason. And that reason entails, firstly, I think the premise that one needs to approach our courts with. If one talks of our Bill of Rights, then we have two approaches. You have the approach in South Africa, where socio-economic rights, as you've heard already, are captured. And in our scenario, you don't have socio-economic rights captured in similar manner as it is done in South Africa, for instance. Dr. Njodi was talking, when he was speaking earlier, he was referring back to the 82 principles and the founders of the Constitution and the like. And I read in his book, he calls it the dead, what's the phrase? The dead hands of the past. The Americans refer to that phrase as the founders of the Constitution. I think we've all heard that in constitutional jurisprudence in the US. So, but he refers it to the dead hands of the past. And he utilizes the phrase by saying, well, it is as if we always reach back and we are led by these dead hands of the past. I think that's a very, very interesting way of looking at it. But the point that I'm making is that we have two approaches, unfortunately. And the South African, as we know, the South African Constitution, there was the interim Constitution in 94, and then there was the final Constitution in 96, which clearly happened after the Namibian scenario. But we also know that in 1990, or prior to 1990, with the constitutional negotiations and the persons who were behind the scenes in framing the Constitution, we know that some of those people had subsequently been involved in the South African drafting of the South African Constitution. So it is as if they had a trial run with the Namibian Constitution, as it were. And then a few years later, it came to dawn upon them, well, you know, we probably need to include this as well, and we probably need to expand on the socio-economic rights and the likes. That is effectively, unfortunately, what happened, because I believe the likes of George Bezos and them had been involved in both processes. Now, I take the two differences and I draw what I call a jurisprudential and philosophical jurisprudential difference between the South African situation and the Namibian situation in looking at rights such as the rights to water and the approach that Dr. Njodi is utilizing. In our Supreme Court, in the Kaweza matter, our Supreme Court took this extract from a statement from the Indian Supreme Court. absolutely necessary for the decision of a case. Now, that is the philosophical, that is the jurisprudential approach of our courts. Justice Masuku had ventured slightly on this point in relation to the state principles, the principles in Article 95 and the approach. So, and I think he encouraged the perspective and a bit more of an adventurous approach. I assume that's what I took away from what Judge Masuku said. Now, that's the fundamental difference with our scenario. In South Africa, in the Jakob decision, the Constitutional Court in South Africa was dealing with the issue of a right to housing. And a right to housing in a scenario where people were evicted, and there's clearly a major issue around that, as we also clearly know in Namibia. In Namibia, we also had in the Supreme Court here the Shanika matter. And the Shanika matter has not been able to deal with that issue in the manner that the Grootboom has been dealing with it, because Shanika matter was restricted to the old ordinance that basically prevented people from loitering and the likes, and allowed the municipal authorities to operate in terms of that old ordinance. That was what Shanika was restricted to, as opposed to really the more broad issue of a right to shelter or housing for that matter. But what the South African court did, the Constitutional Court in South Africa, I just want to read this conclusion that's critical and takes us to the approaches rather. The court in South Africa said effectively the following: I'm conscious that it is an extremely difficult task for the state to meet these obligations on the conditions that prevail in our country. This is recognized by the Constitution, which expressly provides that the state is not obliged to go beyond available resources or to realize these rights immediately. I stress, however, that despite all these qualifications, these are rights, and the Constitution obliges the state to give effect to them. This is an obligation that courts can, and in appropriate circumstances, must enforce. So my point is, the South African courts are allowed and are enjoined by the recognition of socio-economic rights in the Constitution to have a more adventurous and broader approach. Whilst, unfortunately, it would appear our scenario is not the same. And so in having thought about this talk today, I was struggling with that, and this is why I opened my talk by saying, I think Dr. Njodi was very adventurous. It's a very adventurous approach. But what it also does is it engages us, and it allows us to talk. It allows judges to talk and think about the approach of matters before courts, and the enforcement of rights, and the development and expansion of this notion of Ubuntu. Justice Masuku has nicely indicated that to us, and I believe he will have that conversation in the judge's tea room. But at the end of the day, having said that, I also commend Dr. Njodi for the book. I think it allows us to engage. It allows us to take the conversation further. I believe it allows activism on the score. It allows, I believe and hope at some point, government and policymakers to also engage and keep up this discussion, and not just discussion, but to actively do something about it. We know that it's not an abstract issue. The right to water is not an abstract issue, similar to the right to housing. Well, not the right to housing, but questionably, people may call it the right to housing, which is a major issue in our society. So these issues need to be engaged. within not just the legal fraternity, the judiciary, the broader society, institutions such as the Legal Assistance Center. And may I just indicate a personal welcome to the Legal Assistance Director here. She was my former boss many moons ago when me and Norman Chombe were running around the country pursuing human rights issues. So I do have some human rights background. Thank you. Those are my comments. Thank you very much.